And now it's time for us to move on to our next favorite recurring session, Gaming Insights with Segev LLP. And Negin Alavi will be picking up the mantle to discuss the new legislation and requirements that will affect gaming compliance in Canada. Hello, Negin.
Hi, Maria. Thank you. Thank you so much for having me, as always. It's such a pleasure to do these segments. Everyone is so informative, and I love hearing the other speakers. So always great. Yeah, so as Maria introduced me, my name is, thank you. My name is, Negin Alavi. I'm a lawyer at Segev LLP. We're a full service law firm, meaning that we do just about everything except family law, criminal law, but one of our specialties is gambling law, which is something that I do. We have our main office located in Vancouver, Canada, but we also have offices in Toronto, the US, and China. So today I'm going to talk about new legislation and requirements that affect gaming compliance in Canada. This includes 3 specific pieces of legislation: Bill 269, which is advertising requirements. I'm also going to touch on the AGCO's new advertising requirements, and Bill 268, which enables First Nations to establish their own compliance standards. And finally, Bill C-27, which is the enactment of the CPPA and other privacy legislation. So I'm going to touch on all of them. I know that talking about the law is always about talking about compliance. But I feel like these particular new pieces of legislation are going to be particularly modernizing of the respective areas that they speak to. Before I begin, I'd like to acknowledge that I'm giving this presentation from Vancouver, which is on the traditional unceded territory of the Musqueam, Squamish, and Tsleil-Waututh Nations. That means that Vancouver is located on territory that was never ceded or given up to the Crown by the Musqueam, Squamish, or Tsleil-Waututh peoples. And the purpose of that land acknowledgement is twofold. It first pays respects to the Indigenous peoples that are stewards of the lands that I'm presenting from, but it also changes the nature of conversations that are had about Canadian law. So first, getting into Bill 269, which is the proposed national framework on sports betting ads. So as most of you know, being in the industry, Ontario's regulated iGaming regime launched on April 4th, 2022. There was also single event sports betting that became legalized in 2021. And so we've had now some time to see the outcomes that come from these changes. There's been a lot of positive outcomes. If you've been following revenue that's been coming out, if you've seen reports, there's a lot of benefits, and most of them we had foreseen, and we were really happy because the more regulation, the more legalization, the more everyone benefits. Folks have also been reporting things like, robust harm reduction, significant financial benefits. But Canadians have also been providing feedback that some of them feel that there's been basically an oversaturation of sports betting advertising. So during broadcasts of sporting events, there's sports betting advertising, and folks are saying that they're seeing too much, and they're concerned about the types of advertising that sometimes comes out. And so in response to this, there was a proposed national framework, which is the act that I'm talking about, Bill 269. And it's making its way through the legislative process. So the bill proposes rules on a mandatory national framework on advertising, and it's basically trying to restrict the use of this advertising. The preamble notes that a non-standardized approach has been adopted across the country for sports betting, and Parliament recognizes the need for a reasonable and standardized approach across Canada to reduce the incidence and risk of harm. So as I've said, the bill's not law yet. Anything that's a bill is not law yet, but this one's passed first reading and second reading is in progress. I don't personally foresee any challenges to it, so we can reasonably expect that something like this is going to make it all the way down the pipe. It proposes limiting the number, scope, and location of sports betting ads, and even banning the use of celebrities and athletes in sports betting ads. It also proposes to identify ways to promote research and support to combat gambling-related harms. So in order to develop the framework, Bill S269 proposes mandatory consultations. So there's a lot of reporting, a lot of monitoring that's proposed in the legislation. The framework's purpose being to standardize and to have like a national framework is particularly useful if and when other provinces look to consider adopting an iGaming regime that's similar to the one in Ontario. So right now, the AGCO is the body that has the registrar standards for iGaming in Ontario, but that doesn't affect other provinces. The AGCO is focused in Ontario. So if we have a framework like this, folks need to keep in mind that it would affect every province if there's a national framework. There's going to be not just reports, it's going to have policies, and it's going to make sure that, for example, Indigenous communities, provincial gaming regulators, individuals and organizations associated with ethics in sports, and any other person or entity considered appropriate come on board and have representatives participate in those consultations. So yeah, the national framework is still on its way, but it's not guaranteed. However, the AGCO, who I've already mentioned, is the person or the organization that deals with these kinds of things in Ontario. It's also having new rules, and that's definitely happening because it doesn't require that bill to make changes to its registrar standards. So the AGCO also new advertising rules, and it's updated those rules to come into effect on February 28th, 2024. The rules are basically restricting athletes and celebrities in iGaming advertising in Ontario. And that means that you basically can't use those athletes and celebrities to promote gaming. The exception is you can use athletes and celebrities to advocate for responsible gaming practices. So in April 2023, the AGCO held consultations about this type of ban. And in those submissions from the consultations, they consulted with a broad range of stakeholders, including mental health, public health organizations, gaming operators, and the public, and then basically decided that these changes are appropriate. There were already some restrictions and rules regarding advertising and communication. Registrants were already not allowed to use, for example, themes or language intended primarily to appeal to minors. But the additions are strengthening that and making those restrictions more robust. So, and including things like restrictions for social media influencers who are likely to appeal to minors, and the use of active or retired athletes. So the active and retired athletes, particularly, the requirement is new. Yeah, so those are the advertising changes that are coming down the pipe. There's also Bill S268, which proposes to end the provincial government's effective monopoly on the conduct and management of lotteries in Canada. This is very, very huge if it becomes law. In short, the bill seeks to provide the governing body of a First Nation with exclusive authority to conduct and manage lottery schemes on its reserve and license the conduct and management of a lottery scheme by other persons and entities on the reserve. And so the bill seeks to amend the criminal code where a lot of the federal gaming legislation is, and also the Indian Act. The bill is not yet law, as I've said, but I also don't see any significant likelihood of it being stopped. The proposed amendments basically give First Nations flexibility in shaping how lotteries on reserves would be conducted and managed. It also includes charitable gaming licenses, fair exhibition gaming, amusement park lotteries, terms and conditions of licenses, and it significantly mirrors what currently exists in the criminal code. And it's the first time in modern Canadian gaming law where provincial governments do not need to be involved at all in for-profit gaming other than being given notice. So it would change the regulatory and legal landscape of Canada completely for gaming. And what that means for compliance is that if instead of there being a small number of provincial governments that can conduct and manage gaming and betting, there could be an enormous increase in the number of governing bodies that conduct and manage gaming and betting. And so hundreds of First Nations could potentially conduct and manage lotteries on their lands, and each in accordance with their own laws or bylaws, and compliance could look different. So if you were looking to work with a First Nation and to be a part of that, you would need to make sure that you're complying with their particular laws or bylaws. That kind of compliance, would need careful consideration, and you'd need to make sure that you understood the conduct and management scheme that First Nation has put into effect. No First Nation would be forced to conduct and manage a lottery. It would be a choice that the First Nation makes. But if it does make that choice, then compliance would be a huge part of those lottery schemes. The last piece of legislation, C-27, it's privacy legislation. So it's not gaming specific, but privacy, as is obvious, is extremely important for our industry. C-27 completed second reading, and so it's well on its way. And it's got like a long title. It's called An Act to Enact the Consumer Privacy Protection Act, the Personal Information and Data Protection Tribunal Act, and the Artificial Intelligence and Data Act, and to make consequential and related amendments to other acts. Basically, privacy is having a huge overhaul. It's modernizing Canadian privacy legislation. So parts of PIPEDA, which is the Personal Information Protection and Electronics Documents Act, which is the one that normally is in effect or is related, it's going to be replaced in part by 3 acts. So it's the 3 in the long title that I just read. It's the CPPA, which repeals parts of PIPEDA, and it's also the Tribunal Act. So it's the Personal Information and Data Protection Tribunal. So the CPPA, it doesn't just repeal parts of PIPEDA and replace them with a new regime. It goes into detail about the collection, use, and disclosure of personal information. And as you read through the CPPA portion of C-27, you'll see that commercial activities in Canada, they're not just going to have like additional requirements, like meanings of words can change. And so privacy implications for that really matter for organizations that are affected. The second part, the Personal Information and Data Protection Tribunal Act, it creates a new administrative tribunal to hear appeals of orders by the Privacy Commissioner. An administrative tribunal is kind of like a court, but enacted by legislation like this. And so it would hear appeals of orders by the Privacy Commissioner and also apply a new penalty regime created under the CPPA. And finally, the third part is the Artificial Intelligence and Data Act. That's new measures to regulate international and interprovincial trade and commerce in artificial intelligence systems. So it would prohibit specific practices with data and artificial intelligence systems that could result in serious harm to individuals or the interests. So it's got three parts. Each does something major in its own way. And privacy compliance will have to keep them all in mind as applicable. Organizations will be required to have privacy management programs that comply. C-27 will have requirements that organizations not just collect data for appropriate purposes, but it has more criteria over the appropriateness of those purposes. There's more robust protections for children, more rights to individuals over their own personal information. And so gaming industry stakeholders that need to comply need to make sure, especially with their AML and KYC practices, that everything they do is compliant. As different iGaming regimes could potentially open up in different provinces, you'll want to make sure that that these come into mind. And I'm sure that the standards that those provinces enact will have new, whatever current privacy legislation is in effect. So being on top of that and knowing what could happen is pretty major, because you'll be able to prepare for it. You'll be able to instead of scrambling when everything takes into effect. So those are some of the pieces of legislation that are coming in. That concludes my presentation. Thank you for listening, as always. Maria, are there any questions from the audience?
So Nagin, I cannot see something here in the questions. I don't know if you want to add something to what you said so far.
Sure. It's just basically when new legislation comes through the legislative process, it's always a delicate balance, because if you read, it's called Hansard, when you read the conversations that take place with politicians, you'll see that there's a lot of debate, but also folks have delicate balances that they always need to deal with. They always need to make sure that they're balancing all the stakeholders. When it comes to an industry like ours, compliance is really important, because we have such a responsibility when it comes to gaming, and also there's so many benefits that can happen when we're able to have regulated industries. So yeah, I'd like to emphasize that as we watch legislation like this, we're always hoping for more regulation, more opportunities for folks, and instead of us losing revenue, losing talent to other jurisdictions, we'll always prefer for those regulations to be clear and to be reasonable, and to allow for our industry to thrive. So that's all I would add.
It sounds like Canada is taking the right steps towards further regulation and player protection. So thank you. Thanks again. We're looking forward to seeing you again in 2024.